you you Good morning. This is the sentencing of the Parkland school shooter. I'm Janine Stanwood with our legal analyst, David Weinstein. The jury is expected to get the case today. Instructions will be read, so let's listen.
Yes, Your Honor.
Defense?
Yes, ma'am.
Are there any additional corrections, amendments, or additions as prepared?
From the state, the only thing is, Judge, if you look at page 20, I think also, I have pages 20 through 23 corrected so that the rule for deliberation is now at the top of the page. I'm not sure how that happened last night, but also I think we're going to print out weighing the evidence. We'll have the correct.
Okay,
It
so
won't be under the first.
what I'm going to do then is I'm going to put my packet right here, and if you would just switch out whatever needs to be switched and do the same for the defense, otherwise I don't want to get them mixed up. Please.
No problem.
Charlie.
So, David, yesterday both sides agreed to what these juror instructions will be, but it looks like some final fine-tuning.
It's like any project you work on. When you have your completed project done, even the closing, on your house or a loan that you're taking out, there's always some last minute, the way they printed it, the pagination got changed because you used a different printer. And so now they're just going over it one more time to make sure all the pages are the pages they agreed to, all the headings are correct, the page numbers are correct, just the final touches. Because once the judge gets started, nobody is going to stop her, and this is just going to roll through the jury instructions, and when she's done, she's going to tell them, and I'm handing you a copy of these instructions. And so nothing is more frustrating than to say, okay, it's time for you to go deliberate, I'm handing you a copy of these instructions, and somebody says, oh, no, wait a second, we need to change something. So she's taking the delay now before they come in, making sure everybody agrees, and then she'll start the process, and it will go on until she finishes the instructions, and then off to the deliberation rooms they go.
This is the final
All right, let's
copy that
listen.
I'm going to read to the jurors. Is there any objection? Please let me know now, because I'm going to have my assistant make copies.
Oh, for everyone? Or just for for us?
Well, I was going to have her make a copy for the court reporter.
Oh, okay.
But if I don't want to make like 40 copies right now, we can do that. Well, if you need extra copies, we can do it while I'm reading the instructions.
I don't need an extra copy. Can I just come and look at the formatting on yours? And then the substance of mine is the same, I think. It's just the formatting is different.
Sure.
I don't need another copy. Thank you.
Sure.
Judge, just so everyone's on the same page about this, literally, Aaron, Mr. Savitsky will put it on the screen, and as you're reading, he'll flip the pages.
That would be great.
Okay.
Thank you for doing that.
You're welcome.
It looks good.
There's something I didn't like about it, but I'll see. Aaron said that his didn't show it that way.
Is it on hers? Yeah.
Yeah, but
So, David, you said it. They want to cross their T's, they want to dot their I's, they want to have everything ready to go because this is it. This is the moment that the jury will start deliberating once these jury instructions are read.
It's a moment that the community's been waiting for. This is the time where it's all over. Everybody's said their piece. The jurors have now been given their instructions about how they should proceed to deliberate on what's happening.
Aaron appears to have fixed on the version that's going to be shown on the screens,
Okay.
so that's fine. And then after you're done reading them, they go back. We can print this copy out to give them, because I prefer them to have this copy than the one that you have right now. But everything else is the same. It's just one word on one page that got moved back.
So I don't have to read it differently?
No.
I'm not looking at it right now because I gave it to them to make copies.
Okay.
It doesn't affect what the words that are going
No.
to come out of my mouth,
It
just the
doesn't.
way that they're
Yes.
placed on the page.
Yes, ma'am.
Okay. Thank you.
And like you said, this is a monumental task that the jury has, and everybody's watching. The community is watching. You can see David in the gallery, family members, some of them regulars, some we have not seen in a while. They are watching as well.
And all eyes are going to be on that jury room. So it's a task that they undertake, and they know the importance of it. It's been a lot of talk. How long will they take? What will they do? What's going to take place in that jury room? They know that the world is watching them, and so it's going to take them some time. They've got a lot to do when they get back into that jury room, although, you know, many people believe the evidence has been overwhelming for the aggravating circumstances that have been presented, and that while there are a couple of mitigating factors that they should consider, it's not going to be that hard a task for them to do. We don't know what they're going to think when they're in there. We don't know what the individual's perception is at this point in time. The judge has repeatedly instructed them, although you've heard everything, although you've seen all the evidence, do not begin deliberating until after you've been instructed. But that doesn't mean that a juror isn't within their own mind deliberating what they're going to do, going down the checklist. Remember, they've been taking notes, and they can take the notes back in there with them. We don't know what they've put in the margins, what they've decided already, and so many people, despite the fact that you're not supposed to deliberate collectively, have been deliberating individually within their own mind and saying, okay, I know what I'm going to do. Let's hear what everybody else is going to do. But you still have to weigh that process with 12 people for 17 counts. We'll hear from the judge. You're to consider each victim's count individually, and you should make your decision collectively on each individual
It's a
count.
big task enough just coming back and deciding if somebody should live or die for one murder. This is 17. These are 17 individual people. Mike Satz yesterday in his closing arguments basically took the jury once again through what the suspect did, what he did. Look at the comments that he made. Look at the gun that he used. He didn't show it. We were wondering if he was going to show it. He didn't bring it out again. He did show the surveillance video. And the defense wanted the jury to consider, look at who he is. Look at how his brain was damaged. Look at what our experts say.
Right. And look, that's the weighing factor they're going to have to do.
You can see the defendant is right there. Sometimes he wears a mask, sometimes he doesn't. He hasn't been lately. He has sometimes not worn his glasses. Yesterday, he was not really engaging. He was looking down, had his head in his hands a lot. Today, you can see he's with his defense team, as always. The state's team is there. It sounds like they're all just sort of waiting for these details to be hashed out and the printing to be done, so that the jury can, once and for all get these jury instructions, which looked like, when I looked at least the draft of the state's jury form, and they worked off that, and then defense team also put in their input. It was about 90 pages, about 92 pages. Most of the last pages were the forms,
right,
but that's still a lot.
Well, you've got 17 separate verdict forms, and then you have 17 counts, so she has to read those instructions. There are a large number of individual instructions that have to be read, collective instructions, standard common sense instructions that jurors don't think about to get them through the process.
And today they were told, come into court, pack your bags. You're going to go through security. Somebody had wanted to bring in some knitting needles because, you can't have a phone, you can't have an iPad, you can't have any internet. So you can have books. She was hoping to bring in her knitting needles so that she can, at least entertain herself a little bit at night. So the question is, how long will they be sequestered? How long will it take?
Well, and, they keep hearing the word sequestered. I'm not sure any of these people...
Well, just as long as you can see it.
Aaron, is that a yes?
Yes.
You've never been in my division.
Exactly what sequestered
I had a coach in
means.
high school that if you said yeah, you would be in big trouble. So it is in my brain always yes, not yeah.
Apologies, Your Honor.
What's that?
Well, they were told they have to turn off the location services on their phone so the family doesn't know where they are.
I can't think of any way to describe it other than very Lincoln-esque, which conjures up an image of Abe Lincoln sitting in front of his fireplace with a shovel and charcoal doing his work. No cell phones, no electronic books, digital books. You heard her say take off your watches if they're electronic. No phones at all. There's not going to be any newspapers. There won't be any television. If there's television, it's going to be pre-recorded. Potentially, there may be no television whatsoever.
I don't think there is, right?
So this is really log cabin days for these people. And so the question becomes, how will this influence how long they're willing to stay in these conditions in order to reach this monumental decision between life and death? So they go back there today, they take care of business today, they go back to the hotel, have dinner, come back tomorrow morning and work from 9 to 5, and then go back to the hotel. After 2 days of that, it's now going to be Friday if it takes that long, and whether or not they realize it, there is no break for them. They're going to come back on Saturday, they're going to come back on Sunday, they're going to come back on Monday, and they'll keep coming back until they reach a decision. So it eventually will dawn on
And of
them.
course, it's totally your prerogative that if you wish to read the verdict forms to the jury, the state's suggestion, and the defense agrees, you could read count 1 and count 9, and that would you wouldn't have to read all 17 of them. Count 1 has 5 aggravators for that victim, and count 9 has the 7 aggravators. So
We talked about this yesterday, didn't we?
yes, we did, but I don't know if you just made a decision or not, so I just wanted to bring it to your attention, and whatever you think is best.
The adults who are employers of the school, Aaron Weiss, Christopher Hickson, and Scott Beagle, have 2 additional aggravators that the minor students do not.
Yes.
They have 5, the adults have 7.
That's correct. Yes, ma'am. And the first one that comes up as far
Is
as
count
7
9.
is count 9.
Okay. That's fine with me if everyone's in agreement.
So once again, I think we should make clear, we've reiterated this, but I think it bears repeating for sure, that the first thing, as you had mentioned, David, that this jury has to do...
Lining the jurors up, I want to reiterate that for the most part, everyone has been great, including lawyers, staff, guests, but please continue to be very, very quiet. No talking unless absolutely necessary, and we would prefer that people not get up and go out and come back in unless it's very important while I'm reading the instructions, because I want the jurors to be able to really concentrate and be able to hear and understand. Thank you.
Okay, so the audio has been taken away from our live feed at the moment. There might be some internal discussions, but we were talking about, David, that one of the first things then that the jury does once they get the instructions is they'll probably pick a foreperson, and then the first thing they need to do is decide on each count. They'll start with the first one, that at least one aggravator can be proven beyond a reasonable doubt.
Logically, having never been inside a jury room with jurors as part of a jury to deliberate, I'm not sure what the process is, but logically that would be the thing to do. Elect your foreperson, so that person can be in charge, can direct the discussion, can be the person responsible for making sure the verdict forms are signed and that everybody's verdict is contained on those forms. And then, as we'll hear in these instructions, the first thing that they have to do is decide whether or not the state's proven beyond a reasonable doubt at least one aggravating factor for each victim who's been listed. And so logic would be, we'll go through the aggravating factors. So, okay, there's 5 of them for the minor victims. There's an additional 2 for the adult employees of the school system.
And these aggravators, and we've talked about this throughout the trial, things like cold, calculated, premeditated.
Heinous, atrocious, and cruel, the manner it was carried out. Does he have a prior conviction? Some of them, again, logic dictates there's not going to be that much discussion about some of them because they've been proven beyond a reasonable doubt, and so then they'll go through the list, and whether or not they do it the old-fashioned way with a big piece of paper or a whiteboard, or they check them off on some other form, go back to their notes, it's up to them to decide.
And then when they start discussing the mitigating circumstances, all of these circumstances that the defense is trying to present, that he was mentally ill, that he was broken, that he suffered from fetal alcohol spectrum disorder, they then weigh them, but it's not, okay, we have proven one aggravator in this one count, but there are 2 here, so 1 versus 2 is obviously then a vote for life. It doesn't work that way. It's weight, right?
It's weight. It's not quantity. It's not, okay, they have proven all 7, and there's only 2 mitigating circumstances, so therefore, oh, it has to be a death sentence. No, it's going to be, okay, these are the aggravating factors that they've proven. Now let's look at the weight of the aggravating factors versus the weight of the mitigating circumstances, and does one outweigh the other? Now, keep in mind, that's the way it's supposed to work. That doesn't mean that's the way it's going to work. If there is a juror or jurors who believe, despite what they've told us all before publicly about their viewpoints and that I'll weigh all the factors and I could consider death if that's what the appropriate punishment is, there could be somebody back there who says, I was never going to vote for death. I tried to let you know that. Maybe I didn't tell you that as eloquently as you had hoped, but I don't care. And yeah, the rest of you, the other 11 or 10, you're telling me the aggravators outweigh the mitigating? I
Right.
don't see it that way.
I don't feel that way.
It's my independent decision to make, and my decision is I'm not going to sentence somebody to death.
And that is something that can happen. They don't have to be unanimous in how they decide on each count.
Correct.
Now, they do if they want to put him to death on one particular
Correct.
count. They've got to be unanimous under
Right.
Florida statute.
Right.
But they can vote their conscience or their beliefs.
That's what the defense asked them to do. Vote your conscience, be independent, return a verdict that you can live with. And that's what they're hoping for, that there is a juror or jurors who will say, I just can't do it. I cannot. I know what he did. I saw what he did. My gut, my conscience is telling me I can't be the person that did it. Now, what they will have to do when it's over, the judge is going to, well, they're coming in now. They're going to poll the jury, and they have to answer, yes, that's my verdict, in public, in front of everybody.
Thank you. All of the jurors are present. Everyone else may be seated. Ladies and gentlemen, good morning. Please listen closely to the instructions that I'm about to give you. Members of the jury, you have heard all of the evidence and the arguments of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon Nikolas Jacob Cruz for each of the 17 counts of first-degree murder charged in the indictment. There are two possible punishments. 1, life imprisonment without the possibility of parole, or 2, death. Each crime and the evidence applicable to it must be considered separately when deciding an appropriate sentence for each count. Also, a separate verdict must be returned as to the appropriate sentence for each of the 17 counts of first-degree murder. A decision as to one crime must not affect your decision as to the other crimes charged. In making your decision, you must first unanimously determine whether the aggravating factor or factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. Aggravating factors. The aggravating factors alleged by the state are: number 1, Nikolas Cruz was previously convicted of other capital felonies or felonies involving the use or threat of violence to another person. The court further instructs you that where a defendant is convicted of multiple murders arising from the same criminal episode and involves multiple victims, the contemporaneous conviction of murder in the first degree or attempted murder in the first degree as to one victim may support the finding of the prior violent felony aggravator as to the murder of the other victims. A, the crime of first-degree murder is a capital felony. The crimes of murder in the first degree of count 1, Luke Hoyer, count 2, Martin Duque Enquiano, count 3, Gina Montalto, count 4, Alexander Schachter, count 5, Elena Petty, count 6, Alyssa Alhadeff, count 7, Nicholas Dorette, count 8, Helena Ramsey, count 9, Christopher Hickson, count 10, Carmen Schentrup, count 11, Aaron Feiss, count 12, Scott Beagle, count 13, Meadow Pollock, count 14, Carol Loughran, count 15, Joaquin Oliver, count 16, Jamie Gutenberg, and count 17, Peter Wang, are capital felonies. B, the crime of attempted first-degree murder is a felony involving the use or threat of violence to another person. The crimes of attempted first-degree murder of Ashley Baez, William Olson, Kashava Magnapuram, Justin Colton, Alexander Dorette, Genesis Valentin, Daniela Menescal, Samantha Grady, Samantha Fuentes, Isabel Checker, Samantha Mayer, Benjamin Wickender, Madeline Wilford, Marianne Kavachenko, Stacy Lapel, Anthony Borges, and Kyle Lamont are felonies involving the use of violence to another person. C, the crime of attempted battery on a law enforcement officer, Sergeant Raymond Beltran, with a deadly weapon, filed under Broward County case number 18-14129, CF-10A, is a felony involving the use of threat or violence to another person. The crime of battery on a law enforcement officer, specifically Sergeant Raymond Beltran, under the same case number, is a felony involving the use or threat of violence to another person. The crime of depriving an officer, Sergeant Raymond Beltran, of means of protection, also under the same case number, is a felony involving the use or threat of violence to another person. This aggravator applies to all 17 counts of first-degree murder, all 17 victims. Aggravator number 2, Nikolas Cruz knowingly created a great risk of death to many persons. This aggravator applies to all 17 counts of first-degree murder. Aggravator number 3, the first-degree murder was committed while Nikolas Cruz was engaged in the commission of a burglary. And a burglary is defined as the entering of a structure without permission or consent, owned by or in the possession of the Broward County School Board, and at the time of the entering the structure, Nikolas Cruz had the intent to commit the crimes of first-degree murder. Aggravator number 3 applies to all 17 counts of first-degree murder. Aggravator number 4, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime that's intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was pitiless, and was unnecessarily torturous to victims Luke Hoyer, Martin Duque Inquiano, Gina Montalto, Alexander Schachter, Elena Petty, Alyssa Alhadeff, Nicholas Jorette, Helena Ramsey, Christopher Hickson, Carmen Shentra, Aaron Feiss, Scott Beagle, Meadow Pollock, Carol Loughran, Joaquin Oliver, Jamie Gutenberg, and Peter Wang. This aggravator applies to all 17 counts of first-degree murder. Aggravator number 5. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, In order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. This fifth aggravator applies to all 17 counts as charged in the indictment. Number 6. The first-degree murder was committed to disrupt or hinder the lawful exercise of any governmental function or enforcement of laws. Now, this aggravator applies only to Christopher Hickson, Aaron Feiss, and Scott Beagle, who are the adults who were employed working as employees at the time of the incident. It does not apply to the students. Aggravator number 6. Aggravator number 7 also only applies to the adult employees, not to the students. The victim was an appointed public official engaged in the performance of their official duties if the motive for the first-degree murder was related in whole or in part to their official capacity. For count 9, Christopher Hickson was an appointed public official engaged in the performance of his official duties if the motive for first-degree murder was related in whole or in part to Christopher Hickson's official capacity. Count 11, Aaron Feiss was an appointed public official engaged in the performance of his official duties if the motive for the first-degree murder was related in whole or in part to Aaron Feiss's official capacity. For count 12, Scott Beagle was an appointed public official engaged in the performance of his official duties if the motive for first-degree murder was related in whole or in part to Scott Beagle's official capacity. You have heard the evidence about the impact of this murder on the family and friends and the community of each victim. Luke Hoyer, Martin Duque Anquiano, Gina Montalto, Alexander Schachter, Elena Petty, Alyssa Alhadeff, Nicholas Dorette, Helena Ramsey, Christopher Hickson, Carmen Schentrup, Aaron Feiss, Scott Beagle, Meadow Pollock, Kara Loughran, Joaquin Oliver, Jamie Gutenberg, and Peter Wang. This evidence was presented to show each victim's uniqueness as an individual and the resultant loss by their death. However, you may not consider this as evidence of an aggravating factor. As explained before the presentation of the evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proven beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate on the form whether or not you find each aggravating factor that applies to each victim, whether it's been proven beyond a reasonable doubt. As I explained before, there are 5 aggravating factors on each of the students' verdict forms, and there are 7 on the adult employees. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. As such, your deliberations are complete at that time. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. Mitigating circumstances. If you do unanimously find the existence of at least one aggravating factor, and that aggravating factor is, or that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstance exists. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not the appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are the following. Nikolas Cruz is a human being. Nikolas Cruz has neurodevelopmental disorder associated with prenatal alcohol exposure. 3. Nikolas Cruz has alcohol-related neurodevelopmental disorder. 4. Nikolas Cruz was not correctly diagnosed as a child and did not, therefore, receive the appropriate interventions at various stages of his life. 5. Nikolas Cruz was exposed to alcohol in utero. Nikolas Cruz was exposed to drugs in utero. Nikolas Cruz was exposed to nicotine in utero. Nikolas Cruz's birth mother did not obtain proper prenatal care. 9. Nikolas Cruz was 19 years of age at the time of the crime. 10. Nikolas Cruz's brain was not fully developed at the time of the crime. 11. Nikolas Cruz witnessed the death of his father. 12. Nikolas Cruz grew up without a father, raised by a single mother. 13. Nikolas Cruz witnessed the death of his adoptive mother shortly before the crime. 14, Nikolas Cruz lived with a parent who abused alcohol. 15, Nikolas Cruz's adopted mother was not forthcoming to medical and mental health and educational providers regarding his... Nikolas Cruz's adoptive mother was not forthcoming to medical, mental health, and educational providers regarding his birth mother's use of alcohol, drugs, and nicotine during pregnancy. 17. Nikolas Cruz's adoptive mother was inconsistent with his medication regimen. 18. Nikolas Cruz's adoptive mother did not follow all of the recommendations of his medical, mental health, and educational providers. 19. Nikolas Cruz suffered food deprivation throughout his childhood. I'm going to just skip 20 for now and go to 21. Nikolas Cruz is immature for his age. 22. Nikolas Cruz struggled academically throughout his life. 23. Nikolas Cruz continues to try to educate himself despite incarceration and learning difficulty. 24. Nikolas Cruz was sexually abused by a trusted peer. 25. Nikolas Cruz has the following deficits or disorders or impairments: developmentally delayed, severe phonological delay, memory deficits, motor function delays, neurological impairments, social skill impairments, adaptive functioning deficits, executive functioning deficits, central nervous system abnormalities, independent functioning deficits, cognitive deficits, intellectual deficits. 26. Nikolas Cruz was diagnosed with the following during his life: attention deficit disorder, attention deficit hyperactivity disorder, oppositional defiance disorder, reactive attachment disorder, learning disability, speech and language delay, pervasive developmental disorder, developmental receptive language disorder, conduct disorder, disruptive mood dysregulation disorder, impulse control disorder, anxiety disorder, antisocial personality disorder, and borderline personality disorder. 27. Nikolas Cruz experienced risk factors of antisocial personality disorder, including A. Unstable or erratic parenting, inconsistent parental discipline, having 2 first-degree relatives, his mother and his sister, that exhibit antisocial behavior. 28. Nikolas Cruz was declared a vulnerable adult due to mental illness by the Florida Department of Children and Families. 29. Nikolas Cruz was bullied and ostracized by his younger brother and peers. 30. Nikolas Cruz lacked self-confidence and had feelings of inadequacy growing up. 31. Nikolas Cruz grew up in a verbally abusive household. 32. Nikolas Cruz has remorse. 33. Nikolas Cruz was a diligent and conscientious employee and has a good employment history. 34. Nikolas Cruz pled guilty and accepted responsibility for his crimes. 35. Nikolas Cruz has the ability to succeed in a highly structured and supervised environment such as Florida State Prison. 36. Nikolas Cruz exhibited appropriate courtroom behavior. 37. Nikolas Cruz is currently under the care of a psychologist and a psychiatrist in the Broward County Jail. 38. Nikolas Cruz was compliant with his medication regimen in the Broward County Jail. 39, Nikolas Cruz will be punished in prison and society will be protected. 40, Nikolas Cruz is loved by people who will continue to be present in his life. 41, the existence of any other factors in the defendant's character, background, or life or circumstances of the offense which would mitigate against the imposition of the death penalty. Ms. Curtis, can I just see briefly, and Ms. McGann? And read, I wanted to make sure that I was reading it correctly. Number 20 under mitigators is that Nikolas Cruz was medicated throughout his childhood. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh or outweighs the mitigating circumstance or circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mathematical or mechanical process. In other words, you should not merely total the number of aggravating factors and compare it to the number of total mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the result of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factor or factors are sufficient to impose death must be unanimous. And your finding that the aggravating factor or factors found to exist outweigh the established mitigating circumstance must be unanimous. And finally, your decision to impose a death sentence must be unanimous. This process is spelled out in the form of questions, and when you finish question 1, you move on to question 2, so that it makes it a lot easier to understand the process of what do we do next. You will be provided with 17 forms. It's actually, each count includes a different victim, as you all know. And each verdict form for each count and or each victim is 4 pages. And you must fill out all 4 pages because, like I said, there are specific questions about the aggravators and the mitigators and the weighing process that you have to answer along the way. And there are also instructions on the verdict form that will show you when you need to move on to the next question or when you're finished. Again, you will be provided with 17 verdict forms to reflect your findings and a decision regarding the appropriate sentence for each count of first-degree murder. If your vote on the appropriate sentence is less than unanimous, The defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. Weighing the evidence. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have the opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony that he or she gave in court? Had the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe the person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. This witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did not take the witness stand or give testimony in the case. These are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. You must follow the law as it is set out in these instructions. If you fail to follow the law, your decision will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. Your decisions must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of exhibits and evidence, and these instructions. Your decision must not be based upon the fact that you feel sorry for anyone or that you are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision. Your decision should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained within these instructions. In just a few moments, you will be taken to the jury room by the court deputy. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. When you have reached decisions in conformity with these instructions, the appropriate forms should be signed and dated by your foreperson. Your decision must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and they are as follows. Now, I don't want to downplay the fact that there are 17 counts. It's just that there's 4 pages of forms for each of the 17 counts. But you have to carefully consider and evaluate each count as if you were only here to consider one count. In other words, you need to give the same time and attention to each count, each of the 17 counts. With that being said, I don't think it's necessary for me to read the verdict form for every count because as far as the students are concerned, remember there are 5 aggravating factors that are alleged for the students. So the students have one verdict form and then the employees have another verdict form. So I'm going to go over one of the students' forms and one of the teacher's forms so that you can see that there is a difference. But I'm not going to go over all of them because after I go over the first one, I think they'll be self-explanatory. So for example, it starts off, the state of Florida versus Nikolas Cruz, jury verdict form as to count 1, victim Luke Hoyer. Aggravating factors as to count 1, victim Luke Hoyer. The first question you have to answer is, we the jury unanimously find that the state has established beyond a reasonable doubt the existence of an aggravating factor. Nikolas Cruz was previously convicted of another capital felony or of a felony involving the use or threat of violence to another person. And then you check yes or no. After you answer that question, no matter what your answer is, you move to question 2. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of an aggravating factor. Nikolas Cruz knowingly created a great risk of death to many persons. You answer yes or no. Regardless of your answer, you move to question 3. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed while Nikolas Cruz was engaged in the commission of a burglary. You check yes or no, and then you move to question 4. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was especially heinous, atrocious, or cruel. And you answer that yes or no, and you move to question 5. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. The first-degree murder of Luke Hoyer was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification, and you check yes or no. Then you follow the instructions in bold, and it says, if you answer yes to at least one of the aggravating factors listed, so that's the 1 through 5, if you answer yes to any of those, please proceed to section B. If you answered no to every aggravating factor listed, do not proceed to section B. If you answer no to every aggravated factor, Nikolas Cruz is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. If you answered no to every aggravating factor listed, please sign and date the verdict form, which is on page 4. So in other words, if you answer no to questions 1 through 5, you do not have to answer the remaining questions. You just sign and date the verdict form and indicate that you've reached a verdict. However, if you answer yes to at least one of the aggravating factors, you go on to section B, which starts on page 3. And it says, sufficiency of the aggravating factors as to count 1, Luke Hoyer. Reviewing the aggravating factors that we unanimously found to have been established beyond a reasonable doubt, we, the jury, unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death. And then you check yes or no. If you answer yes, you go on to section C. If you answer no, don't go on to section C. Simply sign and date the verdict form and indicate that a verdict has been rendered. If you do answer yes, you go on to C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes or no. And then you can see in the next section, it gives you instructions. Please proceed to section D regardless of your findings in C. So it's important after each section to read the next instructions to find out, do I go on or, do I not? D, eligibility for death penalty for count 1, Luke Hoyer. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt outweigh the mitigating circumstances established as to count 1. And you check yes or no. You go to the last page of, it says Hoyer at the top of each page, so you'll know which verdict forms go together in case they get mixed up. And it says on the top of page 4, if you answered yes to section D, please proceed to section E. If you answered no to section D, you do not proceed. Nikolas Cruz will be sentenced to life in prison without the possibility of parole. Please sign and date the verdict form. If you answered yes to section D, you move on to section E. And this is the last question. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt, that the aggravating factor or factors are sufficient to warrant a sentence of death, and the aggravating factor or factors outweigh the mitigating circumstances, we, the jury, unanimously find that Nikolas Cruz should be sentenced to death. And then you check yes or no. Then the foreperson will sign and date the verdict form. So that is the example of the verdict form that I just went over with you that applies to what I'm going to refer to as the student victims. Okay? There's 14 of them that are identical as far as the form is concerned. Now, they're not identical people, and again, they should be considered separately and apart. The 3 adults have a different verdict form. And I'm going to go over the verdict form for Christopher Hickson to give you an example of what the verdict form for Christopher Hickson, Aaron Feist, and Scott Beagles look like. It starts off exactly the same. It has the name and the jury verdict form as to count 9. It indicates that it applies to Christopher Hickson. You'll see under aggravating factors, section A, the first 5 questions are the same. The only difference is that there are 2 additional aggravating factors that are alleged for the adults, and they are as follows. They're in questions 6 and 7. We, the jury, unanimously find that the state established beyond a reasonable doubt the existence of the aggravating factor, the first-degree murder of Christopher Hickson was committed to disrupt or hinder the lawful exercise of any governmental function or the enforcement of laws. Check yes or no. The adults also have number 7. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the aggravating factor. Christopher Hickson was an appointed public official engaged in the performance of his official duties if the motive for the first-degree murder was related in whole or in part to Christopher Hickson's official capacity. The rest of the form is the same. So that's the only difference, that there are 2 additional aggravating factors for the adults. The adult victims, again, Christopher Hickson, Scott Beagle, and Aaron Feiss. It's set out very clearly in the instructions, but in case you're wondering what the difference is, it's the adults have a 5-page verdict form as opposed to a 4 because of those 2 additional questions. Otherwise, they are identical. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through telephone, writing, or electronic communication, such as a blog, Twitter, emailing, text message, or other means. Now, those of you who are going to be on the panel of 12 won't have the opportunity to do that because, like I told you yesterday, we're going to take your cell phones and only allow you to use them once a day to call home while being monitored. Those of you who in a moment are going to find out that you are our co-pilots, our 10 alternates, you also have to abide by these rules because we may need you. We don't know, and you are not going to be relieved of my order not to discuss the case until you receive word from my office that a verdict has been rendered. Because it is still possible that we may need to substitute an alternate even after deliberations begin. So please, remember, even though you're going to go home and you might tell your family members, I'm home because I was not on, I'm a co-pilot, not the pilot, right? To my one juror over here, whose name I won't mention, Mr. Delta, right? You're the co-pilot, although you still can't talk about it. It's a very big case. It's my favorite airline, that's why I remember. And that they're going to have to just wait. And they might be very curious, but you have to tell them, listen, I've followed the rules up to now, and a few more days is not going to hurt. So let them know you can't talk about it. Okay. Many of you have cell phones here in the courtroom. Like I've told you, you cannot bring your phones into the jury room. You'll need to leave your cell phones on the seat where they will be guarded by the court deputy while you deliberate. Now, the alternates are not going to be sequestered, and we're not going to take your phones. But it's going to be up to you to follow the same rules, except that we let you see your family and watch TV, although you still can't watch anything about the case or the news, and you might be so excited to know what is happening. If that's the case, you can call my office, and my assistant will either tell you, yes, there's a verdict, or no, there's not a verdict. She won't talk about it with you, but if you need that information, you can call her without violating any rules, and she'll tell you whether a verdict has been rendered. However, she is going to call you when a verdict is rendered to tell you you are no longer under the obligation not to discuss the case. Does everyone understand that rule? Please answer out loud. Yes. So if anybody, for some reason, gets your phone number or comes up to you in Publix, or, I don't know, a passenger on a plane finds out that our pilot here is serving on a jury, you cannot talk to them about it. You can't. You can talk to them about anything else, but not this. All right. Do not contact anyone to assist you in your deliberations, and these communication rules apply until I discharge you at the end of the case. If you have become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Remember, as I told you at the beginning of the trial, any notes that you took will be for your personal use. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read them. So, if you find out you're an alternate, your notes have to stay here. We will not destroy the notes until a verdict has been rendered. We will keep them safe, just like we do every night when you leave them here. Your notes should be used only as aids to your memory. And whether or not you took notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of any other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. Prior to the start of deliberations, you will be shown how to operate the equipment in the jury room, which will allow you to view or hear any recordings. Firearms sent back to the jury room have been rendered inoperable, so they cannot be discharged. Not that you would try to, but just so you know and you feel safe, they cannot be discharged. However, if you wish to view any ammunition, we do not send back firearms and ammunition at the same time. If you wish to view the ammunition, let us know. We will have to remove the firearm and then allow you to view the ammunition. Also, if you wish to view any biohazardous material, which I believe is limited to DNA swabs, let us know. There's certain precautions we have to take before allowing you to perhaps touch those items. So put the request in writing, and we will do our best to facilitate that request. Ladies and gentlemen, I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I prefer one decision over another. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have any questions, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law, and no one of us has, no juror, no one of us at all, has the right to violate the rules we all share. I'm going to repeat that because I sort of messed it up. No juror has the right to violate the rules we all share. Okay, at this time, our 10...
Your Honor.
Yes, thank you.
So quick sidebar, it looks like was brought forth by the state, so maybe a procedural question, I'm not sure. She got through these instructions pretty quickly.
Very quickly, and not by speed reading them either. She went through each one, deliberating the words she was using, how she was using, what she was emphasizing, and made it clear to these jurors what they needed to do. The only shortcut she took that everybody agreed to was not reading 17 different verdict forms, but rather summarizing those for the minor victims versus those for the adults who were employed as members of the school.
And the only reason they're different is because the aggravators that apply to those 3 employees, there are 2 more, as opposed to the ones for the students.
Exactly. And so they're going to go back into that jury room any minute now. The alternate jurors are going to get the news, a relief to some, perhaps not to others, that they were simply here to make sure that there were enough jurors to deliberate through the process. She's told them they cannot talk to anybody, they cannot read anything.
And that is because we think that they possibly, just in case, if somebody falls ill or something happens in the middle of deliberations, could they still be called?
Well, not according to the rules, so I'm not sure where this is coming from. The rules that govern alternate jurors allow for an alternate juror to replace a selected juror prior to the jury beginning their deliberations, and that's coming from Rule 3.280, Florida Rules of Criminal Procedures, alternate jurors. And then they talk about responsibilities in capital cases, but the language of the statute says that they're discharged at the same time the jury returned to consider its verdict. Now,
so in this case, they're being told to stay on standby.
But again, I think it's a distinction that we need to take a little bit deeper look into. So the rules about alternate jurors apply in the guilt and innocent phase. So conceivably, an alternate juror will be discharged in a capital case because they're not going to consider guilt or innocence. Now, there's still a capital phase that you have to get to that you in a traditional guilt-innocent case where you use the same 12 jurors to get to the capital part.
Okay, ladies and gentlemen, just to be clear, under the mitigators that I read for you, between pages 11 and 12, because of the page break, one mitigator was separated into two. I did correct it, and I read it properly, but paragraph 15, moving on to the second page, is just one mitigator, and it reads as, Nikolas Cruz's adoptive mother was not forthcoming to medical, mental health, and education providers regarding his birth mother's use of alcohol, drugs, and nicotine during pregnancy. And we will amend that in writing. In other words, we'll give you a clean copy the way it's supposed to be printed before you go back to the jury room. Okay, at this time, the alternates who are not yet excused are going to be taken with the sheriff's office. The sheriff's office is going to take you to retrieve your belongings and to go to your cars like they do every day. Now, we give out certificates. I wish it was something fancier, but this is what the circuit does. And these are a little bit premature because you're not excused yet. But in the event that I don't see the co-pilots on this case, again, I want to have the opportunity to give you your certificate and thank you very much for your time and attention. There's also an order that's attached to the certificate which indicates you were here this week.
Very much. It's nice to meet Ms. Crawford. Thank you.
So right now the judge has left the bench. She's handing certificates to the 10 alternates. They are being told they still can't talk about it. They still have to follow the rules of sequestration when they go home.
Received their certificates early, remember. You are excused. Thank you very much. Excused for the day, not forever. On your chair. So you all are it. You are our jury, our panel of 12. We will, I guess you can just keep your same seats, that's fine. If you would please put your cell phones on the ledge or on your seat. Okay, that's okay, that's okay. If it's in the jury room, if you have it with you, you can put it on your chair. If it's in the jury room, as soon as
We're going to check.
the other jurors are excused, we'll have you all go back and get your cell phone. The clerk, I don't know if you all have noticed, but she sits to my left and she's very, very good and very experienced. And she has reminded me to remind you all, the evidence is in, I don't know if you've noticed, but let's say, for example, there's a flash drive. It's going to be in an envelope and it's going to have a certain number on it. What we ask is that if you wish to view a flash drive, say, for example, that you, when you're finished using it, that you put it back in the envelope that it was in. So in other words, because otherwise it will be very difficult for the clerk to have to go back and figure out what goes with what. Does that make sense? Yes? Okay. Is that good? Thank you. Also, this gentleman right here, who we call Ian, he's our tech genius here, and because I'm definitely not. But he's gonna go back and show you how to use the equipment just briefly. Please don't ask him any questions about the case. He won't answer. He's just gonna say you do this, you press this, and from what I understand, it's very self-explanatory and very simple to use. Also, the sheriff's office is going to give you menus as soon as you get back there, right? You already did? Have you already? How did you do it if I didn't excuse the alternate? Okay, so I understand you've all filled out what you want for lunch, so that's something to look forward to.
Once again, the audio has been cut from our live stream, but David, as you know, those alternates, they were thanked, they were given certificates, they're being ushered out. That might be one reason why the audio was killed. Our Christina Vasquez, who's in the courtroom, says that a couple of them hugged, they said good luck. There's a little bit of a bond that they have. Right now you're looking at Patricia Oliver. She's the mom of Joaquin Oliver. She's been in the courtroom for so much of this.
We're waiting for the alternates to clear out before we're bringing the rest. Okay. But you can be seated. You all don't mind, I don't think.
Okay.
you, Judge.
So we're almost at that
Yes.
point where the 12 main jurors will start deliberating.
Yes, that's a great question. The clerk typed a list, and that's going to go back with the evidence. You're welcome. There's also disposable gloves in case you want to wear. I mean, it's all in plastic. There's nothing dangerous. But if you don't want to touch things that other people have touched, mainly staff and so on and so forth, please feel free to use as many pair of gloves as you want. Yes. Okay. Are they gone? Take them back. Don't shut the door. Ian's explaining. Back. Thank you so much. Bring your notebooks with you. Okay, all the jurors have been excused to begin their deliberations. I'm sure you all have done this, but if you haven't, if you would please give the clerk a contact number so that we can get in touch with you if there's a question or a verdict. Other than that, we're in recess.
Well, David, your heart can just skip a beat right now because both sides have finished their case. 3 months of testimony, more than 100 witnesses for both sides, hundreds and hundreds of pieces of evidence. And you can see these family members. You can see the Hoyers, Fred Guttenberg, so many of them, Joaquin Oliver's family, Debbie Hickson, they're all in the gallery listening, and now they're waiting.
You know, it's all part of the process, and for them, this is helping them with the healing and to get closure, and to quote famous Floridian Tom Petty, the waiting's the hardest part. This is perhaps the worst part of being a trial lawyer. You've done everything you can. It's completely and totally out of your hands now. It's in the hands of 12 people who, before this trial started, you never knew, you knew nothing about, and you've entrusted the process to them. And we always hope that they'll go back, they'll follow the instructions, they'll do what they've been instructed to do, they'll consider the evidence, they'll weigh the factors back and forth, proof beyond a reasonable doubt, and they'll come to a verdict which is just and correct. But
you can see Patricia Oliver is giving a hug to somebody in the courtroom. A lot of these family members have told us that they've wanted to be in the courtroom every step of the way. They've wanted to bear witness. They've not wanted to hear about this secondhand.
Right.
And so go ahead.
They're watching and they've seen it all go through. But again, it's all out of everybody's hands now. Perhaps the two worst parts of any trial are the part where the jury's deliberating, and then when you're back in the courtroom and the judge announces that there's been a verdict and the judge has the verdict in their hands and you wait for them to read the verdict. That's where the anxiety is, at its highest level. But as you can see from the pictures that we've been looking at, the victims' families, the next of kins, they've formed a bond amongst themselves. They're helping themselves get through this process. They, as you said, bear witness to what's going on, and so now they wait. Christina, who was in the courtroom, said that she saw some of this amongst the alternates who were discharged too, up until they told them who they were. They didn't know that they weren't going to be part of the main panel. Right,
we're told that they were actually 22 of them were seated alphabetically, so they weren't sure who the main ones were, who was not, so that they were all paying close attention. And according to Christina, they were. Many of them taking notes intently, many of them wanting to be active parts of this process. And the judge, every step of the way, she's praised these jurors too.
Well, the system doesn't work without them. Prosecutors, defense attorneys, courtroom personnel, witnesses, law enforcement, everybody has a role, court reporter, but without jurors who have now given up a significant part of their daily life and now will give up a lot of hours of their lives to reach a verdict, system doesn't work without them. And as the judge mentioned, we're going to give you a certificate for your participation. That doesn't really, completely fulfill the reward that they should be getting for doing what it is that we've asked them to do.
Symbolizing what they mean not only to this case, but just their part in society and in daily life as Americans.
Right. That's what the Founding Fathers set up when they put the system together. Trial by a jury of your peers, and so we have to go out into the media. And again, an important reason why this case needed to be tried in Broward County. The publicity was worldwide. I don't think, and although the defense tried to move it, there just wasn't a factual support for it. It's a jury of your peers, and the peers of this defendant are people who resided in Broward County. The peers of the victims who survived, of the victims who died, resided in Broward County. So those are the people that should be considering the deliberation for punishment.
So what's happening right now? We're looking at the defense table. It looks like the defense attorney, Mr. Secor, is speaking to the defendant. Maybe he has questions about what's happening. Hard to know. Where does he go after this? He's done.
He goes to the back where he's been the whole time. They will keep him in a holding cell there in the courthouse. I believe the court has said that she's going to give an hour warning to everybody to come back. The prosecutors and the defense team and the defendant need to be on a lot shorter leash than that, because there could be a question. And if there's a question, everybody has to get back in, everybody has to assemble, the question has to be handed to both sides. They need to decide how they're going to answer the question, if they're going to answer the question, what the exact words of the answer are going to be. So they need to be on a moment's notice for that. But he'll sit in the holding cell in the back until the court brings the jurors back in at the end of today's deliberations and says, okay, you're done for today. Go back to the hotel, get a good night's rest. We'll bring you back here at 9 o'clock tomorrow morning to start deliberating, unless they want to start at 8 in the morning. And then it's up to them how long they work. The traditional workday, 9 to 5. If they want to work till 6, if they want to work till 7, it's really up to them. If they're still making progress and they think that they're close to coming up with a verdict on one or more counts, they may say, you know what, we don't. I know it's 5, and we usually go home at 5, but we're going to stay till 6. We're going to stay until 7. It's up to them. They now run the show.
And they're in this jury room right now. If they want to see a piece of evidence that's not in the room with them, they have to request a piece of evidence. What we were told yesterday, both sides for the attorneys went into that jury room to make sure there's no internet access, so they can't look something up. The judge told them to put their phones either on their chair or on the bench so that they wouldn't have access to that. And now they will probably, as the judge had instructed, pick a 4-person. I don't know if that's if they take a vote on that, or if sort of naturally in their interactions they may already know who they want to.
It may work the way that things work, you know, in life. Everybody else takes one step back, and somebody didn't look and ends up looking like they took a step forward. Somebody could volunteer and say, you know what, I'm more than glad to be the 4-person. Or they may have decided, you know, they didn't know who was going to be of the 22, but they know each other. They know who they are. They've formed this bond, and they may have all decided, you know what, we'd like you to accept, and juror X, you're going to be the 4-person here. So, you know, the job is now yours, and you can help us control this. I'm looking to see what time. A little bit too early to order lunch.
Sure.
Even, you know, for third graders.
So maybe they'll make some of those decisions, the 4-person decisions. Right. They make some of the sort of administrative decisions early on. Maybe they want to work through lunch. Maybe they want to order something. It's yet to be seen.
At some point, they'll you know, tell them it's time to order lunch, and they'll give them a lunch. But you know, looking at, you know, my watch here, they've got plenty of time to deliberate. That's a full, you know, it's a little before 11. If they work until 5 or 6, that's a good chunk of time to deliberate. They're not going to come back in an hour or 2 hours, but that's a lot of time for them to consider things today. 17 counts. That's a lot of evidence for them to consider. Improbable that today is going to be the only day of deliberation, but not inconceivable.
You never know. Just before 11 o'clock, the jury is right now in the jury room. The fate of this defendant is partially in their hands because it is a recommendation for the judge. As we know, and we've discussed this before, the jury says yes, unanimously on all 17 counts, or at least just one count. They want death for at least one of the counts. The judge can, I guess, downgrade, if you will, under Florida statute.
Correct.
But if they want life without the possibility of parole, the judge cannot upgrade that.
Correct. If some juror or more than one juror comes back and says life on this particular count, well, that's the sentence on this particular count. The judge may not want to impose the sentence immediately after the verdict. She may want to take a day to, you know, write her order with regard to that. But if they say life, that's the verdict. She can't change it. Not under the rules that are set out now with Supreme Court decisions. If they recommend life for that particular victim's count, that's what the sentence is going to be. If they recommend unanimously death as to a particular victim or victims, well, then we're going to have another hearing. And each side's going to get another chance to sort of recapitulate what they've already told the jurors, try in a last effort to convince the judge on the part of the defense that that's the wrong decision, judge, and despite what the jurors found, it's still within your power to impose a life sentence. She'll hear from, you know, the defendant if that's what he wishes to do, and if he doesn't, he'll be inquired of again for, you know, another time that you don't want to say anything, and then she'll have to decide what it's going to be. I don't know that she'll do it from the bench at the conclusion of that hearing, but she will take some time, set a definitive date for this is when I'm releasing my order and this is how you're going to be sentenced.
In other words, the work is just beginning.
Exactly.
David, thank you so much for joining us. The jury now has this case. They are starting their deliberations. We will, of course, be back as soon as anything happens in court. You will not miss a minute. We'll see you as soon as there's something either decided or a question in open court. We'll see you then. Thank you. you.